Okay, we're going to go ahead and get started. It's wonderful to be with you today. It's great to see so many familiar faces in the audience. I am delighted to be the moderator today of this panel on church autonomy and free exercise developments in the state and lower federal courts. I'm going to start with a bit of an introduction to the topic. We have a lot of lawyers in here who undoubtedly are seeking CLE credit for this panel. Some of you are not lawyers, however, so I'd like this to be accessible to everyone who's here. My name is Hannah Smith. I'm an associate director at the International Center for Law and Religion Studies here at BYU Law School. I'm very pleased to be here with this panel today of esteemed guests, Annika, Boone Barkdull from Schaerr Jaffe, LLP, Carl Esbeck from the University of Missouri, and Blaine Evanson from Gibson, Dunn, and Crutcher. Some of you in this audience have heard me talk about Hosanna Tabor and the church autonomy doctrine before. As some of you know, I was on the legal team at the Becket Fund for Religious Liberty when this case was litigated at the Supreme Court, and I was on the legal team with Professor Doug Laycock, who briefed this case before the Supreme Court. So I'm really excited to be the moderator of this discussion today because I think we're going to hear a lot of really interesting developments since this case was decided in 2012. Just for background purposes, following the passage of the 1964 Civil Rights Act, federal courts unanimously across the country, over the course of about 40 years, developed a legal doctrine known as the ministerial exception. And the ministerial exception barred the government from interfering with a religious institution's ability to hire and fire ministers, including prohibiting employees of religious entities from suing their employers for employment discrimination under the anti-discrimination laws. But the ministerial exception was not recognized by the U.S. Supreme Court, notwithstanding this 40-year-long development of case law by the lower federal courts, until the groundbreaking case of Hosanna Tabor versus EEOC in 2012. So 12 years later, here we are talking about the developments of the church autonomy doctrine post-Hosanna Tabor. And I just wanted to give a little bit of a background from my perspective, having litigated Hosanna Tabor, about that case so that we can all sort of be on the same page as we're having this conversation today. Before the cert was granted in our case in Hosanna Tabor, the Supreme Court had repeatedly denied cases requesting cert on the ministerial exception. There was agreement on all of the federal courts of appeals that the ministerial exception existed and that it was rooted in the First Amendment and that it extended beyond formally designated ministers to other employees that play an important religious role. But the conflict among the circuit courts of appeals back in 2011, which is what we briefed, was the test for using to determine who is exactly a minister. On that question, there was actually a 4-4-4 split, so evenly divided split among the circuits. Some circuits used what was called a primary duties test to determine who was a minister. What was the primary duties of this employee, and does that mean that they were a minister that should be subjected to the ministerial exception? Some didn't use the primary duties test. There were a lot of different tests that were used. Some focused on the time, how many minutes of the day did the employee actually have religious functions. Some looked at a more global analysis. So there were factually indistinguishable cases that were being decided differently in the federal courts, and that's a classic case for a circuit split that the Supreme Court would take. The respondents at the cert stage assumed the existence of the ministerial exception. They did not argue against its existence until the case was actually granted cert, and I'll get to that in a minute. I should note there was also a second conflict that we could have added as a second QP in our cert petition, and that was whether the ministerial exception is a jurisdictional bar under 12b1 on a motion to dismiss for lack of subject matter jurisdiction, or is the ministerial exception an affirmative defense under 12b6, a failure to state a claim upon which relief can be granted. We decided not to brief this in our cert petition. We didn't want the case to get mired in procedural issues. But as it turned out, the court addressed this second split anyway in their decision when they said the ministerial exception is not a jurisdictional bar, but rather an affirmative defense to an otherwise cognizable claim. So cert was granted just on the first question of who should count as a minister under the ministerial exception. It was only at the merits stage that respondents for the very first time suggested that there should be no ministerial exception at all. The Obama administration and the Solicitor General's office pled in their merits briefing that notwithstanding 40 years of settled law in the lower courts, notwithstanding all of their arguments in the lower courts that assumed the ministerial exception, notwithstanding their briefs in opposition to cert and the Sixth Circuit's opinion, all of which recognize the ministerial exception, there should be no ministerial exception at all. That's what the Obama Solicitor General's office argued. That, in the end, I think was a huge strategic error for their case. I think it pushed the justices to a unanimity that otherwise they may not have had. I'm just going to remind you of a few really interesting parts of the oral argument in the first week of October 2011. And as I was sitting in the courtroom that day, you could feel the astonishment of the justices as to the radical position that the Obama administration took. Leandra Kruger, who had clerked for Justice Stevens during my term when I had clerked for Justice Thomas, was arguing the position for the Obama Solicitor General's office, and she said basically that the rights of religious organizations were no different than the free association rights of a labor organization. Now let that sink in for a minute, okay? Justice Scalia, bless his soul, said that's extraordinary. And he said, we're talking here about the Free Exercise Clause and the Establishment Clause, and you say they have no special application. There's nothing in the Constitution that explicitly prohibits the government from mucking around in a labor organization. But there, black on white, in the text of the Constitution are special protections for religion, and you say that makes no difference. And Justice Kagan actually agreed, and she said, I too find that amazing that you think that neither the Free Exercise Clause nor the Establishment Clause has anything to say about a church relationship with its own employees. So there was also a really interesting part of the oral argument where Chief Justice Roberts took the respondents to task for their fallback position, where they said, okay, well, even if there is a ministerial exception, it should be limited to employees who serve an exclusively religious function. And Chief Justice Roberts said, that cannot be the test. The Pope of the Catholic Church is a head of state carrying out secular functions. Those are important, right? So is he not a minister? And I think you saw the justices really pushing back on this very extreme view. The decision came out, it was unanimous. As Michael McConnell said, it was broad, unequivocal, unanimous, and correct. There were some questions left unanswered by the Hosanna Tabor opinion. There was no rigid test of who is a minister. The court was reluctant to state a precise test, but they did give some guidelines. Look at title, look at training, look at substance of the title, how the title is used, how they hold themselves out, and what religious functions are performed. Later, of course, this case was developed further in Our Lady of Guadalupe School opinion. And Justice Alito, who wrote that opinion, said that the title was not dispositive, but the court should ask, what do the employees do? And this is essentially what Justice Alito had said in his concurrence in Hosanna Tabor. A couple of other questions that were left unanswered by Hosanna Tabor that hopefully we'll get to today is, there was also not a definition of what counts as a religious institution. There was no description of what claims or types of claims should fall within the exception, and there have been splits that have been developed since Hosanna Tabor on some of these issues. So today we're going to hear more about the ministerial exception and the church autonomy doctrine and how it's grown since Hosanna Tabor from Carl and from Blaine, and then we're going to hear from Annika about recent developments in free exercise case law in the state and federal courts. So I'm going to turn the time over to Carl now.
Well, as Hannah said, the leading case is Hosanna Tabor, Evangelical Lutheran Church and School versus the Equal Employment Opportunity Commission. And so it's our baseline case. There are some who say that church autonomy, and I'm going to as Hannah indicated, just addressed church autonomy, is under-theorized, but I think the Hosanna-Tabor case has all the theory that's needed in that unanimous opinion to reach a balanced and right result as to what church autonomy is. Nonetheless, 12 years later, we have some circuit splits now just developing, and even splits, interesting splits within circuits. On church autonomy cases, it's not unusual now for the panel to split 2-1, even though the one, it might be a dissent or it might be a concurring in the result only, but nonetheless, on substance that really matters, it's a split within the circuit. So I think it's going to take another SCOTUS case to resolve some of these differences, and hopefully going back to basics. And we're probably going to see that, I would say even hope for that, within the next 2 to 4 years, that there'll be another church autonomy SCOTUS case. And I don't think we should be afraid of that. Right now, as the court is presently constituted, it's favorable towards religious liberty. So there is contention out there, and I don't want to get down deep into the weeds as to the things that are being contended. I want to back up and help litigators as to how they ought to be thinking about these church autonomy cases. And the first thing is to sharply distinguish between the religious liberty claims that are available to litigators and defenses available to litigators under the First Amendment. And it's not just 2 clauses. It is 2 clauses, but it's 3 claims. So it's defenses under the Free Exercise Clause, defenses under the Establishment Clause, and defenses under church autonomy. Church autonomy doctrine is altogether different than the Free Exercise Clause and the Establishment Clause. For example, the precedent for church autonomy cases is a completely separate and distinct line of SCOTUS precedent. There's only about 12, 13 cases over the last 230 years, and it starts with Watson versus Jones, 1872. We can jump that all the way forward to Kidroff, 1952, a case where for the first time the Supreme Court said church autonomy is housed in the First Amendment. We can jump another big leap to Jones versus Wolf, 1979, a polity case, then a long period of silence, more than 30 years, 40 years of silence. But then we get Hosanna-Tabor, which, as I say, is truly a very helpful, theoretically based baseline case. So church autonomy is not an individual right. Individual rights can be waived. Individual rights are balanced. You know, the game under the Free Exercise Clause is get around Smith, get scrutiny, strict scrutiny, balance. That's the game. That's never the case. There's no balancing under the church autonomy doctrine. And that's because it's based upon constitutional structure, not right. You remember back in law school when your constitutional law professor said, look, there's 2 basic questions, only 2 under the federal Constitution. Is it a right or is it structure? And this is structure, and that makes the church autonomy defense altogether different. So you're looking for subject matter pockets of subject matter that fit under the doctrine of church autonomy, and then that particular area is absolute. The case, if it's just a church autonomy case, the case is dismissed. The church is won because it's structural and there's no balancing. So, and let me say, I see a lot of briefs by young lawyers, and they talk about free exercise cases in the same paragraph as church autonomy cases. That makes no sense whatsoever, okay? it's completely distinct, and you're obviously showing a muddled mind if that's the kind of writing you're doing, but also you're confusing the court, not helping them see that church autonomy is distinct and stands alone. So what are these pockets of sovereignty? Well, you look at the Supreme Court case law, and there's basically 4 areas, and I'm going to propose to you a 5th area, and all of these are very moderate. You don't want to over-ask, because not only is it going to be rejected, but church autonomy is so powerful that it's going to scare the court. And if you ask for too much, you're going to end up not only not getting that, but the court's going to react against that and might contract the church autonomy area. So the 4 standard areas of church autonomy, and again, note, I'm using church autonomy as the umbrella policy, and these 4, and I'm going to add a 5th, are under it. So first of all, is it a religious question or dispute? Civil magistrates don't resolve religious disputes. There's no heresy trials in America. The second area is polity, not policy, but polity. Every organization gets to choose its own organizational structure. It could be top down, it could be from the bottom up, with lots of decision-making authority, final decision-making authority at the local level. It could be presbyterial, where you've got elder boards at the intermediate level, and they have the final decision-making authority. Whatever the religious organization chooses by way of its polity, then the government is to defer to that policy choice. And of course, that policy choice means that internal to the organization, when decisions are finally made by the ecclesiastical body, the civil courts are to defer to that. So those are policy or polity kinds of questions. The third area is the employment of ministers. Of course, religious organizations employ a lot of people who aren't ministers, but they employ people who are ministers. And as was indicated, that becomes a definitional question. Who just is a minister? You don't want to over-ask. I see litigators on behalf of religious organizations asking way too much, way too broad a definition of religion. It's not uncommon for me to get called up for free advice, which is fine. And you know, they describe their client, the religious organization. They have 65 staff, and they say everybody is a minister. No, that's asking too much. A court won't buy it. And they're liable in response, because you've lost credibility with the court, to give maybe far too narrow a definition of who is a minister. And then the 4th area is membership. Usually the litigation comes up here in terms of disfellowship or removing somebody from a member, and they bring a lawsuit saying, well, you can't remove me from membership for whatever reasons. And again, those are decisions which are for the autonomy of the church. Then I want to add a 4th area. I can't cite any SCOTUS cases in that regard, but I'm going to cite the Congress and refer to the Respect for Marriage Act, which was enacted in December of 2022, so, a year and a half ago. Section 6B in the Respect for Marriage Act creates a new federal statutory religious liberty right. It's relatively narrow, but what it says is a religious or a nonprofit religious organization has the right, and the right is, if it has to do with the use of the religious organization's property for the solemnization or celebration of a marriage, they are absolutely autonomous. No balancing, absolutely autonomous. Well, of course, this is getting at the same-sex marriage issue. So a church or other religious organization, if they don't want their property used for a same-sex marriage, they have a congressional, federal, statutory right to say no to that. And if there's a state or local public accommodations law to the contrary, it's preempted. Bingo, supremacy clause. Now, how could Congress pass that? Well, you get to the City of Bernie case, of course. Congress can pass laws using Section 5 of the 14th Amendment, looking to existing First Amendment rights. So Congress believes in the First Amendment is, and I'm going to characterize it this way, a right of sacred spaces and autonomy as to religious ritual. So how the religious ritual is used, who gets to participate, or certain sacred spaces, if a religious organization or church has sacred spaces, that's what Congress is building this new federal statutory right on. Let me draw that out just a little bit with another example that's in my one-page handout. Recently, the Biden administration, Department of Education, promulgated new regulations under Title IX, as you know. Becomes effective August 1, which is no sex discrimination at institutions of education. As to institutions of higher education, Title IX notes that universities have university-recognized student organizations. Some of those student organizations are religious. So as to university-recognized student organizations, they often have off-campus meetings of students at facilities that they own and operate. Title IX, under the new reg, says we claim that space, even though it's off-campus and privately owned, and even privately owned by a religious organization, that's subject to Title IX now. Okay, that's an extension of power by the Biden administration. Is that sacred space? I don't think so. You think of the Baptist Student Union, you think of Christian Campus House. Those are private religious facilities, usually right on the edge of campus, so students can always walk there. They don't need to drive there. It may be that the LDS Church has similar types of facilities near state universities. I don't know. But it's not, I don't think, sacred space. So I don't think you would be validated if you claim that as sacred space. But, and just so that we don't give the Department of Education lawyers a complete pass here, the lawyers went on to say that there's been litigation where the courts are split, and we're going to take a side, where religious student organizations, university recognized, they want to choose their officers without regard to sexual orientation, gender identity, and Title IX is now extended to those new bases. And the student organizations that are religious have resisted and said, no, we want to choose our student leaders based upon them taking a statement of faith and behaving in certain moral ways. Now, in other words, if the president of the student-operated Christian Legal Society moves in with his girlfriend, he's going to lose his job as president of the student-operated Christian organization because that's not consistent with the morality of the underlying evangelical Christian Legal Society. All right, so the Department of Education lawyers say, well, that's not church autonomy protected because it's not employment, and therefore it's not under the ministerial exception. Well, they're right that it's not employment, but it is polity. So remember, we got 5 modest scope bases for church autonomy. The second one was polity. And it is polity. It's a religious organization saying, here's the student leaders who are going to lead it. So we get to define the office and define the responsibilities of that office. That's polity. Polity is protected by church autonomy. All right, so I kind of want to close with saying church autonomy is of modest scope, but when it applies, it is powerful. the church wins. Church wins that issue. Now, you can have cases, I cite a 10th Circuit case to you here in the handout. You can have cases that have Establishment Clause cases or issues and free exercise cases. In the case I cite in the 10th Circuit just decided a month ago, there was an Establishment Clause issue. There were 2 free exercise clause issues, but there was a church autonomy issue. All right, so the church autonomy issue, once it was won by the religious organization, it's absolutely won, no balancing. But as to the free exercise claims, you're going to get into balancing there because that's just an individual right. It's not structural. But so I use the word modest in scope. So I intentionally don't use narrow. If I use narrow, I know it'd be quoted back to me in briefs and elsewhere, saying, Esbeck says it's narrow. It's not narrow, but it is of modest scope because it is so very powerful. So I say this to lawyers for religious groups, don't over ask, or you can harm all of us. With that, let me pass the mic to Blaine.
Thank you. I do want to actually add the Church of Jesus Christ of Latter-day Saints does have institute buildings and seminary buildings adjacent to colleges and universities and high schools around the country. And I do think that we would argue that they are sacred spaces. Many of those institute buildings are used for young single adult wards and church services in addition to religious education classes. So I do want to just add that as a post note to your remarks, Carl. Blaine, go ahead.
Well, good morning, everyone. It's an honor to be on this, speaking on this panel at this wonderful event. I am a lawyer at a big law firm. I represent tech companies and sort of big and contentious litigation, and I'm still scratching my head as to why I got invited to speak at a conference on peacemaking. Not usually something you associate with litigators. But the church autonomy doctrine and the ministerial exception we were talking about today is central to peacemaking. It's hard to imagine something more anathema to peace than putting religious leaders on cross-examination about religious beliefs and core doctrine and polity and the like, and subjecting them to the litigation process. So this is really central to a peaceful and a peacemaking society. As both Hannah and Carl mentioned, since the Hosanna Tabor and Our Lady cases, there have been many conflicts in the lower courts that ultimately, I agree with Carl, are going to require the Supreme Court to resolve them. And in the limited time I have today, I'm going to go over some of those splits, some of the issues that have divided the lower courts and that we will expect to see bubble up to the Supreme Court. Some of those disputes concern the scope of the doctrine, either the church autonomy doctrine or the ministerial exception, and what I'll call the substance of church autonomy. Others concern how the doctrine is litigated, and what I'll call more procedural issues. So the first is what is covered by church autonomy. The saying goes that the state can't dictate your hymnal, but it can prohibit human sacrifice. And so there are limits on the scope of that autonomy. And Hosanna Tabor and Our Lady were both employment discrimination claims, where the issue was whether the firing of the minister was something squarely within the church's autonomy that fell within the ministerial exception. And it's easier to see how the decision whether to maintain or fire someone who is a minister applies in this context. We're talking about the religious organization's ability to decide who will lead, teach, and exemplify the values of the religious organization. But it's a little bit different when we're talking about a hostile work environment claim. And on that type of claim that was not addressed in either Hosanna Tabor or Our Lady, and it's divided the lower courts as to whether hostile work environment claims fall within the ministerial exception or the broader church autonomy doctrine, or whether they should be excluded. And the split in the area is a bit messy. A lot of the cases that have not applied the doctrine to hostile work environment claims, a lot of those predated Hosanna Tabor and Our Lady, so it's not clear just how much disagreement there is, but the Seventh Circuit and the 10th Circuit both apply the ministerial exception in hostile work environment cases. The Ninth Circuit, again, it's messy, but probably does not. And the best case that illustrates this is a recent en banc Seventh Circuit case from 2021 called Demkiewicz. And Demkiewicz was hired by a Catholic church in Chicago as its music director, choir director, and organist. He claimed that over the course of a couple of years, he was discriminated against and ultimately terminated. But by the time the issue got to the en banc Seventh Circuit, it was really only about the harassment claim that he was belittled, insulted, and harassed as a result of his sexual orientation. And the district court divided up the claims that he asserted and said, we're not going to let you litigate the claims for your firing, but we will let you litigate the claims for what you assert was harassment, the insults, and the like. And so it sort of split the baby in that way. And the Seventh Circuit panel did the same. But when the case went en banc, the Seventh Circuit fully reversed and said that the ministerial exception applies across the board to all of his claims, both for termination and for harassment. And the court said that this was required by Hosanna Tabor and Our Lady. And to rule otherwise would have courts scrutinizing the religion-minister relationship. So you would have priests and their ministers, their relationship, the supervision, the training, the discipline of the ministers subject to litigation, which is, if not directly what Hosanna Tabor and Our Lady addressed, squarely within the realm of the doctrine. And so what one minister says in supervising another minister might be considered stern counsel to some or bigotry to others. And that line, we let civil juries draw that line in regular secular cases, but the First Amendment prevents juries and courts from interjecting themselves into that relationship when we're dealing with a religious organization. The competing approach in the lower courts, both in the Demkiewicz dissent and in a series of cases out of the Ninth Circuit, is that where the court concludes that it can apply neutral, secular legal principles, that is outside the scope of the ministerial exception. So in a case called Elvig out of the Ninth Circuit, the court said, where the issue was one of harassment and a hostile work environment, where there could be neutral principles where you just litigate this without questioning church doctrine, where what is claimed as harassment is not something that the church says is protected by its doctrine, but is where the dispute is just whether it happened. The Ninth Circuit said, we're going to let that be litigated like any other case. It's just a matter of, he said, she said, and the ministerial exception doesn't apply. And so that's sort of the breakdown of the split. Another area in which the scope of the ministerial exception is still developing in the lower courts is evidenced in a case called Huntsman versus the presiding bishopric of the Church of Jesus Christ of Latter-day Saints, which many of you in the room are probably familiar with. It has been in the press once or twice or 1,000 times. And it involves a man named James Huntsman who grew up a Latter-day Saint, served a mission, paid his tithing for many decades, but in 2015 decided to leave the church and then sued for his tithing money back. And his claim was that he paid tithing in reliance on church statements that it was not using tithing funds for some of its business and real estate development efforts. So many of you are familiar with the City Creek development downtown across the street from Temple Square and church headquarters. The church invested a good amount of money in that development, and Mr. Huntsman says that when the church spoke about that investment, it said, we're not using tithing funds, we're using the returns on reserve funds. Drew that distinction, and Mr. Huntsman claimed that that statement was false, and therefore he was entitled to his money back on a fraud theory. And the church defended the case in the district court on two grounds. One, that the statement was true and therefore was not actionable fraud. And second, on a church autonomy basis, that What we're talking about is the church's internal management of sacred tithing funds, how the church characterizes those funds, and that falls within the scope of church autonomy and is not something that can be challenged. The district court ruled on the first ground, not on the second, but the Ninth Circuit three-judge panel reversed and said both that a reasonable jury could find that the statement was false and that the claim does not fall within church autonomy. Similar to Elvig and the Demkiewicz dissent, the Ninth Circuit panel said we can litigate this claim based on secular, natural legal principles. It's just a matter of whether the statement was false or not, and it's not something that falls within church autonomy doctrine. Now, there are at least two problems with that holding. First is that it's not actually correct, and I'm going to show my bias here that I'm not objective on this matter. It's not actually correct that you can litigate this claim without resort to religious principles. We're talking about the definition of tithing, and whether funds are defined as tithing is a religious question. And whether the president of the church, who is allowed to characterize funds, whether his statements about funds in the church are considered authoritative, those are all religious questions. And especially whether Mr. Huntsman's reliance on the church's statements in paying tithing was reasonable is very much a religious question. And so you can imagine litigating this case before a jury. You'd have experts talking about church doctrine. They would talk about what a reasonable member of the church believes, whether Mr. Huntsman's belief and his claim that he only paid his tithing because he didn't think the church was using funds to returns on his tithing money to help develop the real estate around church headquarters. All of those questions are doctrinal questions, or at least are infused with doctrinal questions, and therefore it's impossible to really separate them and litigate this as any other secular case. And the second problem with it is that church autonomy is not limited to situations where a court or fact finder has to contradict church doctrine or teachings in order to resolve a claim. It is a much or not much broader. I don't want to disagree with Professor Esbeck. It's not a broad ruling, but it at least covers claims where the church's internal governance and its running of things like tithing collection and characterization of funds. That falls within the church autonomy doctrine. The second issue that has divided the lower courts, or another issue, is who is covered by church autonomy, who is covered by the ministerial exception. In many ways, Hosanna Tabor and Our Later were easy cases because they were elementary school teachers, and it was clear in both cases that they played a role in actual religious instruction. They took the kids to Mass, they participated in the liturgy, they had a religious function, and the question was whether they were disqualified because they also had secular functions. But as you sort of move up the ranks of education, high school teachers and college professors, their roles are more heavily weighted to the secular. They do less generally on the spiritual side, and so a lot of the cases that are bubbling up to the lower courts are high school and college professors, where they say, look, most of what I do, the vast majority of what I do is secular. I have this very small spiritual role. I'm not a minister. And a case just decided about a month ago involved a teacher at a Catholic high school, Ballard versus Charlotte Catholic High School. He sued for sex discrimination after the school fired him when he announced his plans to marry his same-sex partner. The Fourth Circuit, though, did not, the Fourth Circuit held that fell within the ministerial exception. Even though he taught English and drama, he didn't teach specifically religious education, but it was part of his job description to infuse Catholic doctrine into English, into his drama instruction. And when he taught things like Romeo and Juliet, he was supposed to teach them with through a Catholic lens. And so even though he wasn't explicitly teaching Catholic doctrine, he was exemplifying the faith, both in the way that he taught English and in his overall example. And the Fourth Circuit found that was enough. So that's really the contribution of Ballard, that a teacher at a religious school does not have to teach religion specifically to constitute a minister. They can teach it through their example. They can teach it through the way they teach a secular subject, and that, at least in the Fourth Circuit, is enough for them to be a minister. That doesn't mean that the janitor or the AV guy or, or someone like that is a minister. I 100% agree with Professor Esbeck that we cannot sort of overstep here, but I think the Fourth Circuit is clearly right that when your Christian values permeate your class, even if it's not a specifically religious class, that falls within the ministerial exception. And the last thing I'll touch on is a procedural issue that has divided the lower courts, and that is the jurisdictional nature of the church autonomy doctrine. Hannah mentioned that in a footnote in the Hosanna-Tabor case, the court sort of resolved this question. It said it's an affirmative defense and not a jurisdictional bar on the court's power to hear the case. But that doesn't answer a litany of questions like, does the court have to decide a church autonomy claim at the earliest possible time? Normally you put off constitutional questions, but when this is a structural issue, there's a great argument that this should be the first thing decided. Can church autonomy be waived? Does a court have to raise church autonomy sua sponte on its own, or does it have to wait for a party to raise it? And critically, can a party take an interlocutory appeal if it loses on church autonomy? And that is a critical issue. I can't tell you how important it is to defending a religious organization that if you lose in the trial court, you're able to appeal immediately without having to litigate the case all the way to final judgment, which is when normally you can appeal, go through discovery, make priests and pastors sit for depositions, have all sorts of things aired during a trial. That is just an enormous burden on a religious institution, and it takes away the very thing protected by church autonomy, which is government intrusion into a religious organization. So even if you go through this whole litigation and you win at trial, or you appeal and you convince the Court of Appeals that there never should have been a trial, if you're a religious organization, you've lost the very thing church autonomy was supposed to protect you. And in many other contexts, in sovereign immunity, qualified immunity, courts have said that that's sufficient to allow what's called a collateral order appeal, and the lower courts are divided on whether that is available in church autonomy cases. So that's one that I certainly see going to the Supreme Court soon.
Thank you very much, Blaine. Annika?
As Hannah mentioned, I'll be discussing free exercise clause cases in the lower federal courts and state courts. One of the key issues right now is what does it really mean for the government to substantially burden the free exercise of religion? The Ninth Circuit addressed that question in a case called Apache Stronghold versus the United States, which dealt with an area of land called Oak Flat. Oak Flat is on federally owned forest land, the Tonto National Forest in Arizona, and it's a sacred site for Apache Indians. They believe it serves as a direct corridor to be able to speak to their creator, and that nowhere else on earth has this direct connection for the types of ceremonies that they want to perform there. They also believe that that site is critical to the spiritual well-being of those who have already had various ceremonies performed there. The problem is Oak Flat sits on top of the third largest deposit of copper ore in the entire world. So the federal government is preparing to transfer it to a private mining company. Congress passed an act to effect that transfer. And when the mining company takes possession, they are going to create some tunnels underneath the ore and use some explosives. And eventually, Oak Flat is going to be a 1.8 mile wide, 1,000-foot deep crater that no private citizens can access, and the Apache won't be able to worship there anymore. And they also believe that that destruction will work harm to those who have had their ceremonies there in the past. So they sued under both the Free Exercise Clause and the Religious Freedom Restoration Act. This ended up working its way up to the en banc Ninth Circuit, which split into actually a couple of majority opinions. One majority of the court held that RFRA should be interpreted the same way as RLUIPA, a similar statute involving prisons and land use, and they overturned a Ninth Circuit precedent that defined substantial burden very, very narrowly in a case called Navajo Nation. But a different majority of the court held that the Apache still hadn't established that they were likely to succeed on their claim because they hadn't shown that the government was going to substantially burden their religion. Now, for that, the court looked to a prior Supreme Court case called Ling. It was fairly similar in facts. The federal government was going to construct a road through Chimney Rock in the Six Rivers National Forest on land that had historically been used for religious purposes by various Native American tribes. And the Supreme Court acknowledged that the road would destroy their ability to worship there, but they still held that the government didn't need to satisfy strict scrutiny to proceed with its plan, because the plaintiffs wouldn't be coerced by the government into violating their religious beliefs or penalized in a way that would deny them their equal share of the religious beliefs, equal share of the rights, benefits, and privileges enjoyed by other citizens. So in essence, they're saying that the Free Exercise Clause wouldn't protect against government conduct that prohibits the free exercise of religion through incidental effects of a government program, which might make it more difficult for some religions to practice their religious beliefs, but that don't coerce those individuals into acting contrary to their beliefs. The government can make something impossible as long as they aren't being coercive. So the Ninth Circuit held that that precedent governed the case, and therefore that the Apache had no free exercise claim. It also held that they had no RFRA claim, so RFRA responds to Employment Division versus Smith, and it essentially attempts to undo Smith and bring us back to a state where if the government is substantially burdening religion, they need to pass strict scrutiny. They need to show that a compelling government interest is served and that the government action is the least restrictive means to serve that interest. But the Ninth Circuit said that RFRA's use of substantial burden incorporated Ling, because RFRA doesn't actually define what substantial burden means. And so the majority of the Ninth Circuit said that we are going to look to how the court was using substantial burden before Smith and assume that Congress incorporated that definition in here. So Ling also governs the RFRA claim. Now, the dissenting justices didn't agree with that. They looked to the ordinary meaning of substantial burden and said that if you are making a religious act impossible, you are substantially burdening that religious exercise, and we should be going through the RFRA analysis here. So that is one circuit's take on what substantial burden is, a relatively narrow definition requiring sort of an affirmative, coercive act by the government. The Fourth Circuit also considered the question of what a substantial burden is in a recent case, Mahmood v. McKnight. Very different facts for that case. The Montgomery County Public Schools in Maryland introduced this storybook curriculum where they introduced various LGBTQ-themed books into their elementary school English curriculum, starting as early as pre-kindergarten. For example, the pre-kindergarten approved book was called Pride Puppy. It shows a puppy who gets lost in an LGBTQ pride parade. It's an alphabet book, so, various A is for, et cetera, and invites preschool children to look for items like drag king, drag queen, leather, lip ring, underwear. Some parents in the Montgomery County schools really didn't want their preschool and elementary school children being introduced to issues of human sexuality, and especially had issues with LGBTQ ideology going against their religious beliefs. Now, for the first year that the Montgomery County Public Schools allowed this curriculum, they provided notice that this curriculum would be introduced and allowed parents to opt their students out. But after a year, they removed the opt-out option. They said that that was necessary because it was getting too difficult to deal with how many parents didn't want their children in this instruction. They couldn't really keep track of who wasn't there, providing alternative lesson plans, etc. So the parents sued the school board, saying that this infringed on their free exercise. It worked its way up to the Fourth Circuit on a preliminary injunction. And the Fourth Circuit, similarly to the Ninth Circuit, held that there's no substantial burden on religious exercise here. They said that parents and children aren't being coerced into changing their religious beliefs. You can still believe whatever you want about LGBTQ individuals. You can still teach whatever you want at home. And that hearing about other views isn't coercive, at least on the record at the preliminary injunction. The court did say fairly frequently throughout the opinion that the record was fairly sparse, and it was possible that when we actually develop the evidence a little more, that we'll determine that teaching 3-year-olds things is pretty coercive because they are 3. But at this stage, the Fourth Circuit said there's no burden here. They also said that there's not a burden on the theory that the parents are being denied a public benefit at the cost of their religious beliefs. So public schooling is a very clear government benefit, but the parents asserted that in order to receive a public education, they had to violate their religious beliefs by allowing their children to receive this instruction. And the court basically said, religious families are still allowed to enroll in public school. They don't have to disavow their beliefs to do so, and so there's no coercion here. Now, the dissent disagreed with that and said that parents are being put to this choice to adhere to their faith or receive a free public education, and that denying them an opt-out puts them to that choice between receiving the government benefit and living by their religious beliefs. But the Fourth Circuit didn't recognize that burden. So we'll see how those cases play out. Apache Stronghold there will be a petition for certiorari coming up soon. I'm not sure whether Mahmoud is going to petition at this stage or go back through the district court first. But we'll see how that and how other circuits address similar questions. Another core issue in free exercise case law is what it means for a law to be generally applicable. Because if a law doesn't apply equally to everyone, then the government has to pass strict scrutiny to justify its burden on a religious exercise. This came up in New York in a case called Roman Catholic Diocese of Albany v. Vullo. New York requires that when New York employers offer health insurance policies that provide hospital, surgical, or medical expense coverage, they need to include coverage for medical necessary abortion services. Now, they exempt religious employers from that, but their definition of religious employer requires that you're a nonprofit, that you have the inculcation of religious values as your main purpose, that you primarily employ people who share your religious tenets, and that you primarily serve people who share your religious tenets. That leaves out a lot of very religious organizations like Catholic charities that serve the poor regardless of whether those poor individuals are Catholic. A number of organizations like that sued New York, arguing that the law was not generally applicable because it exempts some religious employers but not others. This case worked its way up to the Supreme Court. There was a prior precedent in New York that said that this was a neutral and generally applicable law. But while it was pending before the Supreme Court decided Fulton, which elaborates on what it means for a law to be generally applicable. So the Supreme Court granted, vacated, and remanded this New York case for the court to reconsider it in light of Fulton. And the New York Court of Appeals, their highest court, said that Fulton didn't change anything, that this law is still generally applicable, that there are really only two ways that the government policy would fail general applicability. One, if the government is providing for individualized exemptions. So there has to be discretion from the government decision-making body on who gets an exemption or not, or if it permits secular conduct that undermines the government's asserted interests in the same way that the religious conduct would. And so they said these are objective criteria on what a religious organization is, so there's no individualized exemptions here, and we're not letting any secular employers off the hook here. Now, plaintiffs asserted, and I would agree, that there is a problem here because they are exempting some kinds of religious organizations and not others. So you have a religious favoritism problem here. And the criteria also do leave some discretion because you need to decide how many religious beliefs do people have to share and how many people need to share them in order for the organization to primarily employ and serve those who share the religious tenets of the entity. But the New York Supreme Court disagreed with that, said that any statutory term is going to have to be interpreted, and that would just make it so no law is generally applicable. And so the New York Court of Appeals has held that that law is neutral and generally applicable, doesn't need to survive strict scrutiny, and so there is no free exercise claim there. In a case that was also considering, among other things, the general applicability of a law, the Ninth Circuit considered Fellowship of Christian Athletes v. San Jose Unified School District. Now, Carl touched a little bit on similar cases to this in the church autonomy case, but here the Ninth Circuit considered it under free exercise. Fellowship of Christian Athletes is a student organization for, well, Christian athletes. They operate at middle schools, high schools, colleges, and they have a statement of faith that affirms that sexual intimacy is only to be enjoyed in a marriage between one man and one woman. Any student can join Fellowship of Christian Athletes, but if you're going to hold leadership in the organization, you have to affirm that statement of faith. This club operated for nearly 20 years in San Jose without a problem, and then one day a teacher looked into the statement of faith, didn't like it very much, and started leading various protests throughout the school, challenging it in his class, bringing it to the administration. The school fairly quickly stripped FCA of its school recognition, saying that it violated their non-discrimination policy, which at the time was not very fleshed out. Post-litigation, they refined that policy a bit and adopted an all-comers policy, saying that you have to take any student, regardless of these characteristics, into your leadership. But they did allow exceptions for non-discriminatory criteria that they didn't fully define, and they said, well, school administrators will decide that based on common sense. They also allowed exceptions for groups like the Senior Women Club. They could have only students who identified as female as their leaders. The Republican Club could require leaders to support the Republican platform. The South Asian Heritage Club could prioritize South Asian students. A lot of exceptions for secular conduct. The en banc Ninth Circuit said that this violated the Free Exercise Clause, that the Supreme Court has set out at least 3 requirements when it comes to free exercise. One is that it needs to be generally applicable. You can't have a mechanism for individualized exemptions, and that's exactly what the school district had baked into this all-comers policy, allowing for common sense decisions on what qualified as non-discriminatory reasons. They also said that you can't treat comparable secular activity more favorably than a religious exercise, and again, we're doing that for girls' clubs and Republicans' clubs and heritage clubs, but not for the Christians, and that violates the Free Exercise Clause. And finally, they said that you can't act in a manner hostile to religious beliefs, and the school district had done that here. The decision makers had said various things about the Fellowship of Christian Athletes, such as that they were choosing darkness, perpetuating ignorance, that they were charlatans who conveniently forget what tolerance means, that they were twisting the truth, and one word that I can't say on BYU campus. So based on that, they held that San Jose had violated the Free Exercise Clause and reversed the decision below. And So those are some recent developments in free exercise jurisprudence. We'll see how those continue to play out. And thank you all for your time.
Thank you very much. Thank you to all three of you. I think the Fellowship of Christian Athletes decision, particularly coming out of the Ninth Circuit, is a really positive development. And I think that we're going to see potentially the Supreme Court take up that Fourth Circuit decision involving the issues of Mahmoud. I have a lot of thoughts on that. I think, in the theme of our conference, peacemaking means that you let religious groups define their student clubs. In the case of the Fellowship of Christian Athletes, it means in the Mahmoud case that you allow religious parents to opt their kids out of radical sexual and gender identity ideology, which was clearly being pushed on the students in the Mahmoud case. And I think it also shows it really matters who's on your school board. If you live in Maryland and you have children that are in school and the school district says, we're removing your opt-out and you can't take your kids out of this, that's an issue that the school board should have stepped in on and said, that's inappropriate. I mean, the fact that they had too many parents withdrawing their kids, so they had to remove the opt-out, tells you that their policy is radically opposed to the cultural values of their parents. So I think peacemaking in both of those situations means that we allow religious parents and religious organizations to define their doctrine and define their policy. We just have a few minutes for some questions. If you have any questions, please raise your hand. We're going to go a little bit into the break, but we have about a 15-minute break here before the next session starts. So I don't want to cut off the conversation and questions you might have for our panelists. So are there any questions? Yes, go ahead.
Blaine had mentioned a lower court or a split between the Demkovich case in the 7th District and the Elvin case in the 9th Circuit. I was just wondering, I hadn't heard of the Elvin case, so I looked it up. It's the 2004 case, but that's still considered precedent in the 9th Circuit post
Hosanna Tabor.
Yeah.
So he's asking about that split between Demkovich and the Ninth Circuit case.
I don't think that the Ninth Circuit has considered whether hostile work environment claims are barred by the ministerial exception since Hosanna Tabor. Because you're right, that Elvig, and there's another case called, I think, Ballard, that predated Elvig, and that Elvig relied on. Those are both pre-Hosanna Tabor cases. So that's why I mentioned it's unclear what the Ninth Circuit will do when faced with that, but at least, circuit precedent is that hostile work environment claims are not barred by the ministerial exception.
It seems odd to me that wouldn't be, it seems like if you say, well, we're exempt, but it's our policy that we're not going to allow harassment, it seems like that would be more of a contract or policy claim rather than saying that's a federal statute, like in Title VII.
The Ninth Circuit is a really narrow reading of the ministerial exception, and I would say absolutely wrong. If you look at the Department of Labor wage and hour opinion letter, which I give you a hyperlink to, they say all the terms and conditions of employment, if you're a minister, makes you exempt. So you're exempt from wage and hour laws. So that's very broad, and it makes logical sense. You can't just switch from discrimination on the basis of national origin to harassment on the basis of national origin and slip out from underneath the church autonomy doctrine. That's ridiculous.
Yes, over there.
I have a question about both Professor Esbeck's 5 things that you think should be included in the autonomy document. I'm curious, some of the early church autonomy cases were about property disputes, and it sounded like the Huntsman case was kind of about who gets to control property. I'm wondering, why is property not, decisions about who gets to control property, why is that not included in your list?
That's polity. So they are included. It's number 2.
So you would say property basically is
Yeah, well, whichever ecclesiastical body has the final decision-making authority, that's the polity question. And once you decide that, then they decide who gets the property, and the civil courts have to defer to that ecclesiastical decision. That's Watson versus Jones coming forward.
And And I think Huntsman would be a very easy case if it were about property. If it were about whether the church was allowed to spend this money, then that's an easy case, and I think even the Ninth Circuit would have gotten it right. But the way that the case is framed is not about whether the church was allowed to spend that money, but whether the church's statements about what it did were false or misleading. And so that's why it becomes a little trickier, although still, in my view, clearly within the church autonomy.
Good question. Thank you. Any other questions? Okay, well, thank you very much for joining us, and please give a round of applause to our panelists.